Hi, everyone, and thank you, Andriani, for the introduction. I'm excited to be chairing this panel, which will be about other sides of detention. So after having been talking about detention a lot in the previous panels, we will now look at hidden sides of detention and unofficial forms of detention, and how these practices are proliferating and taking shape in different countries. So I'm very excited about this. We have a range of incredible speakers from Greece, Italy, and many different countries. So I will introduce each speaker before their presentation, but before that, I want just to take a moment to flag some logistics. So after the panelists will present, there will be a Q&A session. So please feel free to type the questions into the chat box as you think of them, and with the name of whoever the question is directed to, so if that's applicable. Or you can also raise a hand, and then we'll unmute you when it's the time of the Q&A. And of course, yeah, if you ask a question directly, please try to keep your questions short so that we allow everybody to have the opportunity to ask the question and engage in the discussion. So without any further ado, I think I'll start to introduce our first speakers for this panel. So we have Dr. Lena Karamanidou. I hope I didn't mispronounce the name. Lena is a researcher at the Department of Economics and Law, Glasgow and Caledonian University, and her research and activism focuses on the European border regime, in particular at the Greek-Turkish land border, the EU border agency Frontex, border violence, and pushbacks in the context of the EU border management. And she will be presenting together with Dr. Bernd Kasparek, who is a mathematician and a cultural anthropologist with a focus on migration and border studies. Bernd was working at the University of Göttingen, Germany, in the Horizon 2020 funded research project to respond multi-level governance of mass migration in Europe and beyond. Bernd recently completed his PhD with an ethnographic thesis on the European Border Agency Frontex, and his book is forthcoming in 2021. His further research interests are the government of migration, Europeanization, digital infrastructures, racism, and regime theory. He is a member of the Network for Critical Migration and Border Regime Studies, member of the board of the Journal Movements, Journal on Critical Migration and Border Regime Studies, and on the board of the Research Association Border Monitoring.au. So Lena and Bernd, the floor is yours, and they will be presenting on hidden detention spaces at the Greek-Turkish border, informal infrastructures, border violence, and the European border regime. Thank you.
Well, thank you very much for inviting us to this panel and the nice introduction. Let me share my screen quickly for you. This is not how it works. Lena, is there a chance you can share? Okay, let's try again. Sorry. Okay. Is that working?
Yes, it does. Yeah.
Excellent. Thank you very much. So let's get right into it. So the presentation, which is twofold. I will do the first part, and Lena will take over the second part. As you can see, is titled "Hidden Detention Spaces at the Greek-Turkish Border: Informal Infrastructures, Border Violence, and the European Border Regime." And I think why we chose this title and what it highlights is that we are very happy to present in this context of immigrant detention, workshop, but I would like to say that this empirical data, which we'll be mostly presenting and which is very much work in progress, comes from a different preoccupation we have. That is, for one, the highly special local border regime, which you find at the Turkish-Greek land border at the river Evros. This is the one thing. We have been researching Evros as a particular region for many, many years. Our first research trip took us there in 2010. We think it's a highly special region, and this is why we're happy that we can present a little bit more about it to shed some light on this often neglected land border of the European border regime. And I would also like to add that in the beginning, what kind of drew our attention often to Evros is the involvement of the European Border Agency Frontex. And obviously, it's a very interesting case study also to understand the relationship between the European border regime and third countries, in this case, Turkey. But we will leave all of this aside. I think just that it's important for context to mention it. So let me jump in straight. This is, you see the red part, that is the Greek-Turkish land border along the river Evros. In Turkish, it's called Melric. In Bulgarian, it's Marica. And you see it's this is where three countries converge. It is a key crossing point into Greece and the EU since at least since the 1990s. We're still working on completing the history of migration across the Evros land border.
And sorry
yes.
to interrupt you. I think the presentation is not moving according to your talk. So I think there's something with the power. We can just see the first slide with the title.
Ah, okay. That's not good, because
no.
the second already. Which one do you see now?
Always the title, only the title.
Lena, can you share?
Yes, I can share, but you need to stop sharing.
I did.
Yes. Let's see.
Thank you, Lena. With these technological platforms, it happens all the time.
So can you see it now?
Yeah, I can see the title, the first one. Yeah, I don't know if you can try to use the presentation function, like full screen.
Okay.
Yes,
perfect.
Perfect.
So apologies for that. Let me not repeat everything. It's just, you see the red region, that is the province of Evros, or North and South Evros, on the map. And as we said, it's separated by the river Evros, which gives the name to the region, which pretty much flows along the border of Turkey on the right and Greece, Bulgaria to the north. And it's a key crossing point into Greece and the EU since the 1990s. There is two border crossing points, the big one, Kipi, and there's a very small one in the vicinity of the Turkish city Edirne called Castagnes. And as we will point out now, since the late 1990s, this region has a very interesting and ambivalent development of immigration detention facilities, because we would argue that Evros is, or the region of Evros is largely excluded or excised from the European asylum regime. The border has been heavily militarized for many, many decades. It's only since 2008 that the mines which have fortified the border with Greece have been removed. But still, from a lot of testimony which we have looked at, dating back to at least into the 2000s, it is very clear that it is practically impossible to make an asylum application in Evros, but that the vast majority of asylum seekers and other people seeking international protection will just be pushed back in the narrow sense, in the legal sense, to Turkey. And I think this is something that the global public has become familiar with at large in March 2020, like 1 year ago, when there was this very exciting border conflict. But we would just like to point out that this is a development which has been going on for at least 3 decades, stretching back into the 1990s. Okay, can we? So what we want to highlight is that we think that the detention landscape in Evros is also characterized by hidden detention spaces outside of official detention facilities, of which there are very few. We would like to get into a discussion of spatial, temporal, and functional aspects of the organization of detention spaces in Evros. And of course, for us, very important is how they relate to the predominant practice of pushbacks in the areas, pushbacks to Turkey. And a bit more in our general interest, the implications for understanding border violence as state violence, as a state crime, and the larger European border regime. So this is a map of Evros region, enlarged a little bit. You can see we have been trying to enumerate and cartograph, and this is really the work of Lena, fantastic work, the official existing infrastructures in the area. And you see that it's a lot of border guard stations, which are denoted by BGS, and police stations. Also keep in mind that there's a heavy army presence, Greek army presence in the region. And as we would like to point out, all of these all of these border guard and police stations, which often double because they have cells, which often double as detention spaces, are mostly strategically located close to the border, of course, which can facilitate pushbacks. There are 2 special facilities which we would like to point out. In the very south, you see the Poros detention facility, which triggered our whole investigation into hidden detention spaces. And in the north, you see Phylakio, the so-called pre-removal center, or ProKK in Greek, which is at least 15 years old. And one might add, it has also been extended in 2013 with the reception and identification center. But this is the main detention infrastructure in Evros. But as we will show, it is often not enough. And here, because I think I need to come to an end, you see a couple of pictures. This is part of our ongoing investigation, trying to push to bring information together. So on the lower right, you see Phylakio. This is a picture we took in 2010. The yellow house is it used to be a makeshift, but as you can understand, it has been existed for many years now. The detention center, the pre-removal center. For example, on the upper right, you see Tichero border guard station. This picture has been taken from a train which happens to pass behind the station. And you see that there's a cage-like infrastructure on the outside, which can also be correlated with testimony. And on the left, you see other border guard stations which exist throughout Evros. Okay, and I will pass on to Lena here.
Yeah. Apart from the official border guard stations and police facilities that are used for detention in the area, there has been a number of other more informal and in some cases formal detention centers, like the one in Vena, which is strictly speaking in the Rhodope prefecture, that were used as detention facilities throughout the years, specifically since the very late 90s. Vena was in operation, and also the first detention site, which is mentioned in a CPT report in 1999, was a warehouse that was repurposed for detention. And as well as the first warehouse, other warehouses were used in Peplos, Elafohori, Vrisica, and Zikia, which are all villages in the area. And how these warehouses look like, oops, sorry. I think now my PowerPoint presentation froze. Sorry for a minute.
It's not moving.
Is it showing?
We can see the disused
We can
detention
see.
facilities.
Yes, because I'm trying to move on to the next slide. Sorry about that.
Maybe if you click escape.
Yes, let's try this. Yes.
Yeah.
So, where was I? Yeah, here. So, these are all photos from the disused sites, and you can see they look quite similar because they were all with warehouses that were repurposed for detention. So, apart from those sites that are now disused, we have the example of Poros, which is a kind of different case because it was originally a military facility that was repurposed for being a reception and screening center in 2012, and then later on in at some point in time that we're not too sure about, it became a temporary detention facility. And this kind of shift in purpose was not widely known, but was revealed in 2020 at the same time with a border inverted commas crisis in Evros by research and journalism, including by forensic architecture, the New York Times, and ourselves. Now, apart from those facilities that we know about, there are a lot of testimonies and reports about pushbacks that point to other sites being used. For example, we have references to stables, old rooms in houses that are not identified as detention sites, open areas fenced in. So a lot of different types of buildings, along with warehouses that are not really recognized as official detention facilities. And on the other hand, we have in the testimonies of people who have been pushed back, references to being detained in military facilities, places within barracks. And as Bernd said earlier, there are dozens, literally, of military camps in the area. To move on, because, sorry. What we see in Evros is essentially a network of hidden sites for detention, including agricultural, farming buildings and military sites that exist alongside official detention facilities. So there is still a possibility that some of the disused sites that we talked about might be used. In fact, the Greek government had made a statement to that end back in 2008, illustrating in a way the fluidity of use of spaces for detention, depending on the requirements for detention in the area. And it's also very clear that all these detention places that we are unsure of where they are, the hidden detention places, are very directly linked to practices of pushbacks. Poros, for example, very clearly was identified as a holding center prior to pushbacks. And the other detention sites that we don't know much about, that are mentioned in testimonies, are used for the same purpose. Which means that in essence, in Evros, we have two systems of of detention working in parallel. One is the formal detention infrastructure in police stations, Fylakio, and to a certain extent Poros, now it is known. And at the same time, we have a network of hidden informal facilities that are a lot more difficult to locate. And I think this points to certain issues around access to rights, including the right to asylum, unlawful detention in the area, the absence of documentation and registration of people detained. There is, of course, no oversight or monitoring of informal facilities. And in terms of how we think about detention as border violence, and we have talked earlier in sessions today how detention is essentially a form of violence. It isolates people, causes harm. With the kind of hidden facilities we have in Evros, I think this is exacerbated as a pattern of violence. We have people who we don't know where exactly they are detained, under what conditions, people who have essentially disappeared from the legal to an extent system of detention in the area. And I think we're probably over time. Yes, sorry, so I'll stop here. And there are a few more issues that this research is leading us in terms of how we research those centers. It's extremely difficult both because of the militarization in the area, but also because we need to do a lot more historical research to pinpoint those sites. And thank you very much. Sorry for the technical problems. And I'll stop screen sharing now. Thank you.
Thank you, Lena and Bernd, for the really interesting presentation. I think I have a lot of questions and curiosities, but I will leave them for the Q&A. And so with no further ado, I'll give the floor to our next speaker, who is Kristin MacDougall-Sullivan of Fenix Humanitarian Legal Aid in Lesvos. So Kristin is a lawyer, licensed in the United States, and has been practicing law since graduating from the University of Connecticut School of Law in 2012. After practicing in the renewable energy field, Kristin completed a master's degree in law and diplomacy through the Fletcher School at Tufts University. Kristin focused on human security and public international law while at Fletcher and completed her thesis entitled Falling Through the Cracks, Single Men in Moria Camp. In May of 2019, Kristin began working with Fenix Humanitarian Legal Aid in Lesvos, Greece, and is currently the coordinator of the international legal team who focuses on interview preparation and supporting asylum seekers in their first instance decision. So thank you very much, Kristin. And Kristin will be presenting the paper entitled Moria 2.0, Controlled Camps in a Closed Island. Thank you.
Thank you, Francesca. Yes, so as Francesca mentioned, I'll be speaking about the context of the sea border between Lesvos Island and Greece. Lesvos is one of 5 Aegean hotspots that received an overwhelming amount of new arrivals of asylum seekers between 2015 and 2016. At one point, Lesvos was home to the largest refugee camp in Europe, Moria camp. The camp actually burned down in September of 2020, but before that, the island had a population of over 20,000 asylum seekers. So there's been a few different phases of the, I would say, narrowing of people's freedom of movement around the island and off of the island here in Lesvos. So I'll start briefly by giving context in describing the EU-Turkey statement which was concluded in 2016. Essentially, the purpose of this statement was to keep arrivals of asylum seekers that reached the Aegean Islands, the 5 hotspots, having the possibility to be returned from Turkey unless certain conditions were met. So essentially, there's 2 different procedures for asylum between the Aegean hotspots and the mainland of Greece. In the border procedure for asylum seekers that arrive on the islands, there's an additional hurdle to show the asylum service that Turkey is unsafe for you to be returned to pursuant to the EU-Turkey statement. So that functionally exists as a way to keep people on the islands. So people are geographically restricted to the island of Lesvos if they arrive on the shores of Lesvos until the processing of their asylum claim. If they make it past an admissibility hurdle, it's potential that they'll be transferred to the mainland, but until that happens, they're confined to the islands. So the most recent development has been in conjunction with, of course, the COVID-19 pandemic. So right now in Lesvos, there is a quarantine area, which is in the north of the island, in an area called Megalothema. It's about 50 kilometers away from the nearest hospital and about 55 kilometers away from the main city here in Lesvos, Mytilene, which has shopping centers and things like that. So within Megalothema, there are a lot of things that ensure the area is serving as a detention area. So the basic needs within the quarantine area in Megalothema are widely reported as not being met. Right now, the only presence in Megalothema outside of the Greek police is MSF visiting once a week to provide basic healthcare needs that they can. And then the Greek Medical Authority, AODY, does COVID-19 tests. Other than that, there's no presence of NGOs. The only other actor within the quarantine area is the Greek police. So this has led to a lot of issues, as you can imagine. I'll just go over a few of them, but there's many more that I won't discuss. Most recently, MSF issued a briefing note in May of 2021, where it laid out some of the most acute issues with the Megalothema quarantine area. So one of them is that there's no defined time limit for people to be in quarantine before they're transferred to the new site, the camp that replaced Moria camp, essentially. People have stayed there for 2 weeks, people have stayed there for a month, people have stayed there over a month, and there's no clear defined time limit of when someone will be held in the quarantine area. One issue is with regard to refoulement from the inside. So in the MSF briefing note, it was reported that on February 17th, there were 5 men, 3 women, and 5 children that arrived to the shores of Lesvos from Turkey. They went to a state reception facility where police told them they would be taken for a coronavirus test. These people were locked in a container for an hour and then put in a van, forcibly transported to a port and put on a boat and left in the middle of the sea in an inflatable boat so that they would theoretically be picked up by the Turkish Coast Guard. So we've all been hearing about pushbacks, and this is an issue in the quarantine area from inside the site even. As far as basic needs go, as I mentioned, there's a lack of medical care. MSF visits once a week. MSF has reported several incidents where medical care was needed and was not provided. For example, there was a pregnant woman with hypothermia, which luckily MSF was able to see the next day, but had there been more of a delay in the medical care, of course she could have died. There's also no psychological support. So many of the asylum seekers, as you can imagine, are arriving with a number of psychosocial needs. There are survivors of torture, survivors of sexual violence, people with severe psychiatric conditions, and as of yet, there's no psychosocial support or referrals to mental health actors from the quarantine area. The area exists with a fence around it, and then there's 11 cohorts, so groups of tents that are padlocked at night. So from the afternoon until the morning, people are padlocked and essentially left abandoned. The only people in the area would be the Greek police, who are responsible for calling the ambulance in the event of emergencies. As far as legal process, the people that are in the quarantine area essentially exist outside of the asylum process. So their their expression of will to apply for asylum is not registered until they're transferred to the new site in Mytilene, Lesvos. So essentially they have no access to legal aid as well. One way in which this can have devastating consequences is there was a person who arrived to the shores of Lesvos as an unaccompanied minor. He stayed in quarantine for 32 days. And when he was then registered, he had turned 18. So instead of having the legal process of an unaccompanied minor, which has many more procedural guarantees here in Lesvos, he was registered as an adult. And that was simply because he was not transferred to the camp before his 18th birthday. Though when he got here as an unaccompanied minor. So this is just an example of many of the issues that can arise from having a lack of access to the asylum process. I think in the first presentation, we saw that the informal detention centers, one of the consequences is that there's no documentation of people that are in these type of structures. And this is similar to the quarantine area in Lesvos. So as far as once a person is transferred to what I'm calling the new site, the site that exists in Lesvos after Moria was burned down, there's movement restrictions as well. So right now, residents inside the camp, asylum seekers inside the camp are only able to leave about once a week. And the process is really difficult. You have to have the correct registration number. You have to wait in line. I've heard examples where people waited in line for hours because they needed to go grocery shopping. You have to queue early in the morning. And if you have an appointment with your lawyer, with your doctor, with your psychosocial support provider, you must have an appointment slip from that provider in order to exit the camp. Conditions keep getting more and more confined for people in there. For example, we're hearing now that there are some reports that those even with doctor's appointments, even with medical appointments, are not allowed to leave the camp and are being randomly given rapid tests for COVID. So those are kind of the informal detainment systems that exist in Lesvos. And again, I'm not covering all of the issues because we don't have enough time. I could speak all day about the different struggles that people face as a result of these informal mechanisms. But as far as formal detention in Lesvos, there's been kind of two different phases. So I'll talk about how the detention mechanisms existed before Moria was burned down in September of 2020, and then after at the new site, and then also the plans for the future, which contain another closed camp plan. So when Moria still existed, as far as formal detention mechanisms, the Greek police issued a circular in June 2016, allowing the detention of those arriving from low recognition countries. So these would typically be asylum seekers arriving from countries of origin that had a 20% or less recognition rate historically. The maximum detention timeframe at this point was 90 days. And essentially the impact was that all of the detainees under this regime were single men. So in the summer of 2019, for 3 months, there was constantly single men being detained, arriving from these low recognition countries, and also subjected to an expedited asylum process. So there was a fast track procedure called under the pilot project or under the implementation of the 2016 police circular that attempted to have asylum claims processed for these people within 25 days. Detention prevented these asylum seekers from accessing effective legal aid, from accessing psychosocial support that could have removed barriers for the asylum process, from accessing a number of things that became most of the time insurmountable hurdles for asylum seekers arriving to Lesvos. So that was prior to the fire that destroyed Moria. When the fire happened in Moria, the pre-removal center was destroyed. And as people were essentially confined to a few area block in Mytilene, not allowed to leave police barricades as they were rendered homeless after the fire, and then contained in, like I said, a small area of maybe 5 or 6 blocks. The pre-removal center was destroyed, and the former detainees were essentially allowed to be part of the rest of the group of people from Moria that now have their homes destroyed. After the fire in Moria, there was the rapid construction of a new site called Mavrovouni Camp, which is about 10 minutes drive from the former Moria camp. Inside that camp, there are the practice of low recognition detention has stopped, but it can restart at any time. It's really at the discretion of the Greek police. So right now, there's only about 7 detainees, a combination of administrative detention and criminal detention. And these detainees are actually somewhere in the north of the island. There's not a lot of information about that facility. So finally, plans for the future in Lesvos include a new closed camp, which will be about 18% smaller than the current Mavrovouni camp. It's about 245 acres. The camp area is basically in the middle of nowhere with no access to food facilities, medical facilities, hospitals. And the permit was actually just approved on the 15th of May. For the construction to begin. So the theory is that all asylum seekers that are now in Mavrovouni camp will be transferred to the middle of the island in a new closed reception and identification center for processing of asylum claims. So I'll just pause there. That was a very quick overview. And please feel free to ask me questions if you'd like me to speak about anything more specifically.
Thank you, Kristin. It was very, very interesting presentation, perfectly on time. So thank you very much for this. I have seen we start to have a lot of questions in the chat, but we will leave them for later for the Q&A. So I will now give the floor to our next speaker, which is Giulia Crescini from ASGI. And Giulia is a lawyer and a legal consultant who deals with the right to international protection, children's and women's rights against discrimination and illegitimate practices. Since 2017, Giulia Crescini is the scientific manager of the Shabaka and Uruka projects of ASGI. And sorry, I've lost and as part of the project, strategic actions are presented to counter the policies of externalization that limit the right to asylum and movement of African citizens. So Giulia will be presenting today a paper on the right of confinement in airport transit zones and obstacles to the exercise of the right to asylum. So thank you, Giulia. I can't see you.
Here I am.
Okay.
Okay. Good afternoon to everybody. And thanks to Francesca for inviting me and inviting ASGI to this important event. As Francesca told us, today we are going to talk about detention in the airport transit zones. You can find all the information and more specific details on the report that we published with ASGI. Airport transit zones, as you probably know, are the areas between the landing point of the aircraft coming from abroad and the customs control. From a legal perspective, there is no specific definition. The purpose of establishing such areas is to allow the transit of persons and goods through the national territory without the need for entry formalities. It is generally recognized that it is possible to cross the transit area in order to board another flight, even if one does not have a visa for entry into the country through one is transiting. By means of a legal fiction, states consider the transit area to be not yet state's territory, and therefore something like an extraterritorial zone. These areas play a key role in the management of migration. In fact, border authorities perform a fiction of non-entry to simplify the procedure of expulsion on foreign citizens and to implement mechanism of informal selection of incoming migrants. The lack of a clear legal definition of transit zone has led to a basic ambiguity on which illegitimate practice of refusal of entry and detention have been built. The border authorities, considering this area as extraterritorial area, so they act as if they were in a free zone that are out of the application of constitutional, national, and international standards for the protection of fundamental rights. This interpretation, as you can see, is not consistent with the rule of law, since the jurisdiction exercised by the state over such places is not in question. In spite of the absence of specific regulation, there are in fact several rules in the Italian and European legal system that establish how these places should operate and what the rights of foreign citizens who find themselves crossing should be. Foreign nationals who find themselves in transit zone are entitled to all fundamental rights, including the rights of asking asylum, the rights to defense, the rights to personal freedom and security, the rights not to be subjected to inhuman or degrading treatment, and the rights to private and family life. Today we will see how the fiction of non-entry affect the personal freedom and the rights not to be detained without a judicial order. At the border crossing point, the police authorities carried out the controls provided by the Schengen Border Code. So a foreign citizen coming from a foreign country who is present at the border crossing point is subject to the checks aimed to check if the person has all the requirements for entry into the territorial into the national territory. If the border authorities consider that this person does not meet the requirements, he can be subject to immediate rejection. According to the provision of the Italian immigration law and the Schengen Border Code, border police is required to immediately return the foreign person who has not the right to enter to the country of origin or the country of transit. However, it's possible, and actually it's very common, that the carrier is not available for several days. In these cases, the citizen, after having received the notification of the rejection of entry, are held in the security areas of transit zone, pending the execution of the removal. In this case, People who are vulnerable, for example, they have only the possibility of moving in the limited spaces of the transit area, which in any case does not seem to be equipped to meet the needs of vulnerable people. During this period of waiting for the carrier, the foreign citizen is deprived of his personal freedom, and in this condition, he can have difficulties in communicating and defending himself. The restriction has no legal basis since it is not provided by any legislative provision. Moreover, the legitimacy of the detention is not subject to judicial review. For this reason, we'll usually speak of a de facto deprivation of liberty for people who await repatriation even for days. As the Ombudsman for the rights of persons deprived of their liberty that I know spoke this morning, in the areas of transit of Malpensa and Fiumicino, for example, in 2018, more than 500 people waited for the execution for the repatriation for a period from 3 days to 8 days. According to the interpretation of the border authorities, the stay of foreign nationals in transit zone does not have the characteristic of a form of detention, but consists in a simple prohibition of entry implemented in compliance with the provision of the Schengen Border Code. This is because the Schengen Border Code does not establish a time limit for the execution of the measure. Actually, international and national court has already stated that in these cases, we are in front of a limitation of personal freedom. The first decision was the decision Amour versus France that probably you all know that was issued in 1996. But then we have another important decision of the European Court of Justice, FMS and others versus Orzagos, in which the court analyzes the situation of deprivation of the liberty of the claimants who were asylum seekers detained in the transit zone established by Hungary at the border with Serbia in order to control entry from third country. The court established that the placement of asylum seeker or third country nationals subject to a return decision in the transit zone should be classified as detention. Even the Constitutional Court, the Italian Constitutional Court, has identified the element of coercion as qualifying the restriction of personal freedom. So in this case, we can see that we have all the characteristic of detention. In fact, the foreigners in transit areas are subject to constant and strict surveillance by armed border police personnel and may not in any way leave the video surveillance premises in which they are confined, and they can't leave the airport transit area, neither to go back to their country of origin. In addition, people detained in the transit zone, they have limited ability to communicate with the outside world or to have access to defend. It follows, as you can see, that such detention is adopted informally without the issuance of a measure indicating the reason and the expired date, without the legitimacy of a deprivation being verified by judicial authorities, and without the right to an effective remedy. In our report, we're analyzing some possible strategic litigation against the illegitimate deprivation of liberty of people in transit zone At first, it's possible to present a criminal appeal in front of the criminal court, or maybe an appeal in front of the civil tribunal, in which you can ask damages to be indemnified. In fact, we have people who spend several days in transit areas without any form of justification. Of course, when you are limited in your freedom, other rights can be infringed. First of all, the rights of asylum, and then also the rights to be defended. To conclude, there is an urgent need to put an end to such violations. Civil society and the judicial authorities must play a primary role in the protection of human rights and act to ensure that the authorities involved in the management of transit zone comply with the existing guarantees in force regarding the respect of the rights of foreign nationals in such areas. Thank you all, and I thanks again to Francesca, because I can see that she has already shared the link to our report.
Thank you, Giulia, for the very interesting presentation. I suggest all the people to have a report. And she just
Francesca, sorry, we cannot hear you very well. Can you maybe
hear me now?
Yeah.
Can you hear me? Okay. I was just thanking Giulia for the really great presentation and saying that all the people who are interested to know more, because she just gave a very brief overview, I suggest to read the report, which is really fun. So I will now give the word to our next speaker, who is Laura Lo Verde. Laura is a PhD student in Human Rights, Evolution, Protection and Limits at the Faculty of Law of the University of Palermo and a member of Cledu, Legal Clinic for Human Rights of the University of Palermo. And Laura today will present us a paper entitled Quarantine Ships, a Temporary Measure or a New Approach Beyond the Emergency. So thank you, Laura. And yeah.
Thank you, Francesca. Is it working? Yes. Can you hear me? Okay. Okay, so first of all, thank you for the invitation. And as Francesca said, I'm a PhD student. I'm basically here because I'm a member of Cledu. Cledu is our legal clinic for human rights in Palermo. That is trying to carry on some works, even the situation, the sanitary situation. In fact, my speech that is about this new, totally new approach in Italy, so-called the quarantine ship approach. It was the base of a work carried out by some students from our clinic in collaboration with ASGI. So, as I say, is a very new approach, and in fact, I will give you some legal framework about this. But what it will emerge it's that we have very few information because of this, of course, because it's new, but because it's not a very transparent approach. So it started on 7 on April on 2020, almost 3 months later, the declaration of a state of emergency here in Italy, and with an interministerial decree. It was issued that for the entire period of the duration of the health of emergency, Italian ports do not ensure the necessary requirements for the place of safety. Due to this, a few days later, on 12th of April, another decree was issued by, this time by the head of the Civil Protection Department. This decree instituted the use of so-called quarantine ships, where people rescued or arrived independently will spend fiduciary quarantine. So even in this decree, it was issued that the Italian Red Cross would be present on board during all the proceedings. So at the beginnings, it was just a measure for people who was rescued on the sea. But after, because of there were no possibility to allocate people who arrived autonomously in other areas or facilities, these measures, so the quarantine ship approach, it was instituted even from people who arrived autonomously. So it's been contradictory and paradoxical, because it's like Italy is going to be a little bit distort the international obligation, for example, that state has to protect declares that Italian ports are unsafe, but, for example, continues to finance resettlements in Libya, who is, of course, a place in war. So it's totally contradictory and paradoxical. Even these, basically, all people that arrived in Italy since the 7th of April were transferred in those quarantine ships, and last month it was like 10 people that 10,000, sorry, not 10, 10,000 people that spent the quarantine period on those ships. We know right now that the Ministry of the Interior say that this measure will be adopted until the end of the emergency. So right now it depends on the sanitary emergency. Sorry, my laptop. Okay. As I said before, we have very few information about what is going on really on those quarantine ships. The critical profile that emerges from this observation that the Cledu with other association on the territory in Sicily, or basically in Palermo, and even with ASGI, all those critical issues are are several, and they are worrying. For example, all those critical information critical issues are linked to the lack of information about access to legal information, for example, to ask for international protection. And it is emerged on for example, one of the association in Palermo noticed that the people that were disembarked from the quarantine ship, they had, for example, a degree of expulsion after this. So it's probably because even they didn't know that they could ask for international protection, or maybe all those critical issues, they are about the access to an appropriate health care, due, of course, appropriate to the condition of people that they are coming from a very dangerous journey, and other critical issues where they are absolutely linked to the vulnerability and the screening of situation of vulnerability, and I'm referring to, for example, for accompanied minors, but I will speak more detail later. So our cooperation with ASGI pointed out, because they present a civic access to Sicilian institution to understand how many people were transferred in those quarantine ships. And for example, basically for unaccompanied minors, how many accompanied minors were in the or are right now in the quarantine ships, and if the procedures implemented to ascertain the minors' age are good or not, or if they do it, and how many, if the guardianship is established, and how many guardians have been nominated, and even about the place where minors spend their quarantine period. For example, they've been with adults, so they have a specific place on the boat, on the ships. So from this access, this civic access and the analysis carried out by the students of Cledu, it emerges that all the critical issues that I say, they are more worrying about unaccompanied minors, and all the information that we have, they are not just linked to the civil access from ASGI, but even unfortunately from a tragic event that occurred on September and October 2020 here in Palermo, because because a tragedy occurred because a 15 years old Ivorian boy died after he was rescued and after transferred to a quarantine ship here in Palermo, and after died in a hospital here in Palermo. So even his precarious condition were being noticed, and the Italian Red Cross were on board and knew about it. He was disembarked only like more than 20 days. He was already on the quarantine ship. But the real cause of his death, they are in ongoing as I say, investigation. So after this, we know all the details about that. For example, guardians were not nominated before this tragedy, and we understand that it's clear that in the name of security, in this case as security, there is a very worrying balancing between collective rights and individual rights. So we are trying to continue to monitor all the situation, and given the sanitary situation and the vaccination, we hope that the government try to abandon this approach to have a more transparent that can protect people. Okay, I finished.
Thank you, Laura. Really on time. Very interesting presentation again about new forms of unofficial practices of confinement and I think a lot to reflect on. So before going to the Q&A session, we have the last speaker, last but not least, Ayla Spatopoulou. I hope I did not mispronounce the name. So Ayla is a research associate in Glitch, an ESRC standard grant project that examines how financial and digital technologies are transforming refugee governance in Jordan, Lebanon, Greece, and the UK. Ayla is also the co-founder of the Feminist Autonomous Center for Research in Athens, and her research focuses on processes of bordering, island detention regimes, politics of refusal, and participatory action research methodologies. And today's paper is entitled Changing Spatial Temporalities of Detention and Deportation at Europe's Borders, the case of the Greek hotspots from 2015 to 2020. And thank you, Ayla. I give you the floor.
Yeah, thank you very much for the introduction, and for Andriani and Francesca for inviting me to this very important, very difficult conference on an issue that's hurting and is continuing to hurt a lot of people and harming. I think that my presentation will be kind of brief because also it's the last presentation today. So I think, we're all the end of the day. And I think that so much has been already said that I would not like to repeat many of the things that have already been discussed and said. So I will just go briefly over my main points, what I want to say for today, and then hope that, we can have a broader discussion afterwards. I just want to kind of make just one point clear, because when I was looking at the title, there's this like time frame from 2015 to 2020. I don't want to kind of give or let's say reproduce a false presumption that for some reason we're kind of at the aftermath of the hotspot, I don't know, can call it era, or of the hotspot. We're above and out of the hotspot system. That there's been really some discussions kind of circulating, especially since the fire of Moria in September 2020, and kind of discussions around what the new EU Pact on Migration and Asylum is doing, is kind of that we're at the end of the hotspot era into a new era. I personally don't believe this is the case. If anything, just like we are entering its, how would you say, normalization and the internalization of the so-called hotspot approach. And I'm purposely using the term approach here because I think this is what this is mainly about, and it's a way that the EU and states are approaching certain populations around mainly racialized lines as a problem to be managed, and along the line of crises. It's a way of seeing and visualizing people. And here I am grateful to my colleagues at the Feminist Autonomous Center, Anna and MacDougall, for pointing out the kind of oculocentrism that has been at the beginning of the hotspot approach, tied with this like implosion of the photography that goes hand in hand with this. And I just wanted to make this clear that the time frame basically indicates kind of the research I was doing directly on the hotspots for my PhD studies. So I just wanted to make this clear because it came to me after as a kind of point. And the observations that I will say now, I owe a lot to my work, as I already mentioned, to my colleagues here in Athens, and to the work that I'm doing at Glitch. A lot of it's been influenced by, of course, Martina Tazzioli. So a lot of the things will probably sound familiar to you, the kind of approaches of the research. Just briefly, I want to go over how, what I'm going to do is kind of, let's say, this preparing for this presentation gave me the opportunity to kind of reflect a little bit on some of the main directions that we are moving towards since the imposition of the hotspot and the first hotspot on Lesvos in 2015 until now, in light also of the EU Pact on Migration and Asylum. Please, these are just like some main points that I would like to go over. And of course, I believe that the people on the actual islands, especially legal activists, that have a lot more to say, and I'm happy to hear their especially their comments on what I am saying, because it relates a little bit to the asylum system. And of course, it's also important that at this moment I'm talking from my specific location in Athens, which of course is as I think it's become clear, it's not cannot excluded as a site even from the whole hotspot approach, being specifically in Greece, but in generally in Europe. So basically, my PhD was very much about what we've already heard, like mobile and embodied, the kind of mobile and embodied carcerality that the hotspots entail. So this kind of like carceral conditions that move beyond the actual site of the, let's say, site of detention, the site of the prison. And of course here, particularly like the work of feminist geographers have been very much influential. This kind of idea of mobile hotspots is not something that I just introduced. I mean, we heard Martina Tasioli's talk on how mobility is used as a kind of political technology of control. And of course, being the hotspots being on the island, situated on the island, I analyzed very much this hotspot, let's say, regime through the kind of analytical lens of the ferry as an illustrative tool with which to critically explore the specific politics of mobility that are being put forward with the hotspot, and as a very actual means of transportation, as it kind of creates is what Martina and Glenda have referred to as an island-mainland dialectic between the island and the mainland. So how the kind of logic of the hotspot moves beyond the actual site, detention site. And another point that was kind of explored was the kind of how the hotspot regime is based on this kind of like very precarious and racialized labor. But I won't go into this now. So what I'm going to say now comes out from this kind of approach of the mobile hotspot. So thinking of mobile hotspot as a result also of mobile detention, whether it takes place as we have seen on the ferries. Of course, pushbacks are, I won't go into details, but they also, I believe, should be thought alongside the hotspots approach. So my main 3 points, just what I feel, and just by speaking with people that are either active legal actors or let's say people on the move that are suffering from detention at the moment, I think that 3 things I would like, I think for me have become kind of clear, is this idea of like the death of asylum, that I think is, of course, it's clear that this is happening, and how more and more people are being impeded and obstructed from to access the asylum system and from the right to apply for asylum. But I think if we are talking about the death of asylum, it's very important to kind of think how asylum is being used, is the right to apply for asylum has been, let's say, how can we use the word, maybe like I don't know, like taken over by the EU Commission, and is more and more used against people. So it's not like it's disappeared completely, but it's become a reason, if anything, to another route, let's say, another deportation route. This is just a kind of feeling that I kind of have just by looking since 2015 until now. And this was clear already to some groups of people that knew from the beginning that they were going to, they were not going to be granted asylum, as Amanda mentioned, like all this. It was taking place at the hotspots. It's like lower than 20% EU acceptance rate. So there were groups coming from particular places, for example, people that were perceived as coming from Pakistan or Northern African countries. That I just, when I was on Lesvos, I remember just before the imposition of the EU implementation of the EU-Turkey statement deal, they were actively refusing to register and apply for asylum, because that would basically mean their detention on the island, and basically the rejection that would enable then the EU authorities to move on with their deportation. So this was something that kind of became clear then, and my feeling is that it's just expanded to more groups of people that have just got used to basically the fact that they're going to be rejected, and rejected twice, because of course there is an appeal. So this double rejection, and this has become the new normal. And it's a kind of like, on the one hand, you need the asylum, of course, to protect yourself supposedly from deportation. On the other hand, it prolongs your detention. So it's this kind of Janus phase of asylum. And plus, I think more and more we see, kind of spatially speaking, and the hotspots plays a crucial role in this, how like geographies of reception, asylum, and so-called return, and people keep referring to return, essentially deportation, of course, become intersected and blurred, so that it's difficult to kind of discern the difference between the asylum procedure and the return procedure, in my opinion, because it's there's so much closely now through detention. Like you can detain now. Detention becomes a means through the whole asylum process. So when someone is started to be like the removal procedure, preparation for removal starts to take place, has already started when one even implies their intent, registers their intent to apply for asylum. And this is my second point, that I think we can speak of more and more of a kind of like a criminalization of intent, what in Greece is called like a voulicy, more and more like what through the whole pre-registration phase, and so more and more the fact that people are even expressing their intent to apply for asylum puts them in this position that they have this kind of form of agency, and this more and more that is being interpreted as abusing the asylum system and as delaying their return, their deportation process. So this, of course, is been for some long time now with the kind of like subsequent asylum claims that, of course, instead of proving that people, if they keep applying for asylum, means that they are in danger to return for whatever reason, do not want or cannot return to the country, is on the opposite, being used now as a kind of reason for all this EU Pact on Migration and Asylum that says that people are abusing the system and delaying asylum because exactly their asylum, let's say, abuses. So they're kind of being immediately, even by the very fact of expressing their intent, as are being conceptualized and governed as so-called economic migrants, let's say. And this, of course, goes all around the idea of agency, choice, that we saw very much playing at the hotspot, and it functioned in various forms, from even the very so-called more like a benign aspect of the hotspot regime, relocation, that people were like transferred not to the countries of choice, and or if they, for example, refuse to be sent to a particular location, immediately they could be threatened, expelled from the asylum system. And this brings me to the last point on how detention is expanding to more and more groups of people. We can speak of the kind of like shrinking of the figure of the refugee in this sense, and we see even people that gained the refugee status when they were got the geographical restriction lifted from, for example, the hotspot islands, and arrived on the mainland. They had nowhere to go, and this kind of re-encampment, re-detention policy took place from the main square, for example, in Athens, and they were evicted from there and taken to a pre-removal deportation center of Amygdaleza. And how, for example, we see in cases now, especially since the pandemic, how detention has been used as a kind of, let's say, solution to the homelessness, the crisis of homelessness. And how these kind of categories, like how the economic migrant refugee binary has been exploded in this way through this idea. So basically, if you're not accepted to be an object, a passive object, to be transported, transferred, or stay put, depending on the will of the authorities, you are somehow interpreted as not being a real deserving refugee. And this is really ironic, because some of the main reasons that now people, at least on the mainland, I can speak for, the ways the lawyers are trying to help them get out from detention, is basically to prove that somehow they have been financially integrated, let's say, into the society. They have to prove that they have they contributed to the wait, I'll find the translation, 1 minute. I can't find it now, but it's basically about that they have a job permits, so the kind of way to be able to somehow have the hope of uplifting their detention order is through this kind of supposedly financial integration, and this is like makes it so when one category can be you can be used, for example, the category of the refugee on for your advancement, it suddenly turns against you, and vice versa. The same with economic migrants. So it's kind of a situation. And I think my last point will be in light of the kind of what we're seeing now taking place. There's been a lot on mentioning on this kind of idea of fiction of non-entry, and this is very much we see basically the expansions of the hotspots. So basically, the EU is trying to provide a legal basis for what's already taken place with pushback. So this kind of like trying to prevent people from arriving on the territory. So we're going to suddenly be in a situation that if, for example, the accelerated, so basically they're trying to like multiply the accelerated border procedures, and if for some reason they cannot take place at the actual borders, for example, on the hotspot islands, the member state has a right to do this in any location, in other locations within the territories, which basically means that we are going to have these suddenly this new category groups of people that are not really asylum seekers, but they maybe intend potential asylum seekers. So this kind of subcategory of asylum seekers where their legal rights, of course, will not be clear. And basically, yeah, that's the kind of relations that are going to be established with people that are here but are not here, and how this affects affects our everyday lives and interactions will be something to be seen. So basically, yeah, this is what I wanted to say. These are kind of just kind of like, yeah, how, and just one last thing is that kind of spatial temporalities, let's say, that we see, and the hotspot is one of them, but we even see it like this idea that what I kind of say as asylum towards a return, we even see it taken deeper in Europe, like deeper European countries, with a kind of more like precarious legal statuses that have been given to people, even people that were relocated. A lot of them now have been, their asylum claims, their asylum permits have been revoked, and have been told that at some point they will have to return even to countries like Syria. So if we see it kind of in long term of what all this so-called refugee crisis of 2015, the hotspot approach has been, you can say that it's been in some cases like through immediate and very like violent forms of deportation at the borders, and then this other more like mundane but not less violent forms of convincing people or telling people that they have to go back. And yeah, that's what I wanted to say. Thank you.
Thank you.